Thank you so much for coming to our panel, either live and in person here in Washington, D.C., or virtually. We have a very tight program and not a lot of time to get through what is really a fascinating and complex subject. So with your permission, and in advance for the people who aren't yet in the room or will be joining later, we will get started. My name is Natalie Reed, and I have the pleasure and privilege of serving as the moderator for this session. Just for everybody, making sure you're in the right room, this is Can Alternative Accountability Mechanisms Provide Effective Human Rights Remedies? The panelists' bios are in the program. I will not eat up a lot of time rehearsing them, but I encourage you to review them. Please also remember to use the handy meeting app to post your questions. There will not be a Q&A session at the end. We will pull the questions from the app. Our session today deals with the alternative accountability mechanisms set up primarily by companies and international institutions to address serious adverse impacts of investments and development projects, including human rights violations and serious environmental harms, in situations where it may be difficult or impossible to obtain recourse through local courts or government intervention. These mechanisms reflect an organization's attempt to provide remedies pursuant to the UN Guiding Principles on Business and Human Rights, similar soft law instruments, and evolving best practices. Today, we will hear from panelists with significant experience and expertise on the subject, discussing the enduring challenges of setting up these mechanisms and ensuring their effectiveness, lessons learned from the past decade or so of practice, and how we can make the next generation of mechanisms more effective for the individuals and communities most affected. I'm joined in person by Margot Day of Accountability Council and Mark Wielga of Nomogaya, virtually by Suzanne Spears of Allen & Overy and Archana Kotecha of the Remedy Project. In keeping with the theme of this year's annual meeting, however, we'll start with a recorded discussion with Jeff Sebagala of Witness Radio Uganda, who speaks about his experience representing communities before two of these mechanisms, and will thereby help us ground the discussion in the lived experience of those directly affected. Very much for joining us through this video. Could you introduce yourself to our audience?
Hello, everybody. My name is Jeff. I am based in Uganda, and I work with Business Radio Uganda and the Northern Advocate for the protection and promotion of indigenous community and rights. We had one, the CAO process, and we have also had an opportunity to the first group to interface with the inspection panel of the World Bank, as well as the dispute resolution party. I think the case we're working on is a pilot case in Uganda, which is trying the dialogue to work.
Beginning with the first example, the IFC accountability mechanism, can you tell us a little bit about the harm suffered by the community that gave rise to the need for engagement with this kind of mechanism?
Most communities, that is the community that is saw the coming on of the cow process, this community had lost their property when the beneficiary of the World Bank money never had the opportunity to consult, never had the opportunity to value property of the community, never had the opportunity for the community to have alternative settlement. What you are seeing mostly in Uganda is confrontation. Because in Uganda we have about 75% of the land in Uganda do not have certificate of ownership. And communities that have been on their land for many years when land is given to investors, there is no due deficit. There is no due process that is used to check whether their community, that community suffers the brutality of police, the army, private security guard, and it is after that we got to know the company. After studying about the company, we realized that the company had benefited from IFC funding. By the time the evictions were ongoing, we had organized the community. We had gone to court, but the investor did not stop with a court eviction. Instead, continued even when there was a court order stopping the company from continuing with that court eviction. So that tells you that the coming of the cow process made a lot of sense for the community, because even when at the end of the day it was good bazaar, but the community, I can say, were able to see the investor and then the financier at one point. The World Bank and the company were adamant at responsibility, but through our allies in the global north, the issues really were brought, and there was a lot of serious engagement with the World Bank, as well as other financiers, including HSBC. So from that, that is when, because of the advocacy from international NGOs, there was quite a number of cries from the ground. That is when the attention was given. And mediator was appointed, who eventually came, met the community, explained what ownership really means. And but one thing that I should say is that even when such mediation was offered through PAO, there was no valuation or checking what one owned before. And whatever was offered for us was really business, because a few those who benefited, their life wasn't. Then imagine those who did not really benefit. It tells you that up to now, majority of them resorted to go and live in the refugee camps. They changed their identity because they thought refugees were being looked after by the government of Uganda, because the government of Uganda received funding from the government partners like the European Union. Others really are suffering. Former landlords are now reparations. It is really painful, very painful. And the government of Uganda is not doing this. Instead, it was using its officers from the lowest level to the district level. Instead, they were issuing rates. I remember on one of the radio stations, the representative of the president had even the guts to announce that I should be arrested. Whoever is me around, I should be arrested because I was confusing the community. So, and that's the situation with the
Let's turn now to the World Bank accountability mechanism that you mentioned. Where are you in that process? Where do things stand?
Very disappointing. I'm sorry we speak negatively about the so-called international financing. Instead, the government of Uganda, through the Kampala Capacity Authority, wanted to use the Public Health Act to hide behind that act to and ran away. When that came to our attention, we go to the World Bank. Tell the World Bank there is a problem with the financing. The Ugandan office did not attend to us. We wrote, we made follow-ups until we contacted our partners, Accountability Council, informing them the challenges that we are facing. And the Accountability Council was able to reach to the reporters of the World Bank. Within a short period of time, the World Bank Kampala office got back to us. Very disappointing. And this is when we saw the World Bank office organizing a meeting with the FAP, together with the officials from the government. And guess what? Even what the World Bank recommended for the government to do was not done. The World Bank never did not carry out supervision. What we saw was the maintaining of the status quo. And we had to push together with our partners at Accountability Council, which again wasn't really an easy process. Now is again the government of Uganda trying to confuse the past, bribing some people to confuse the entire process. To one point, the World Bank is not careful. People may cross because one, there seems to be really quite a number of delays, and there are social issues that people occurring, and the mechanism doesn't offer any way for these victims to live. They have lost their property, their children are no longer going to school, they cannot feed themselves as before, and this process is not offering any alternative survival until the process ends. Yes, they're talking about a year, the year is supposed to take like maybe a year.
What do you think a meaningful remedy would be for the members of this community?
And for the World Bank to own up and take responsibility, and the beneficiary or the institution that is happening to receive the money from the World Bank should also take responsibility and make sure that whatever things were committed, one, are rectified and the right thing is done, whereby their property, people need their property to be valued fairly. They are looking for settlement. They are also looking for damages that they have suffered. That is really what the community would understand. And by that, we fear that this may not be really meaningful because they are living as refugees, and looking at that and how the process is being handled, chances are that they may also fall free like they are. But compensating them will be the best way for them to get justice.
Jeff couldn't be with us today, but he sends his very best regards and thanks all of you actually for your attention to this issue. With those words as a starting point, let's recap briefly where we are in the history of these mechanisms. Suzanne, we'll turn to you first. Can you give us a brief sense of the current state of play, where we are and how we got there with alternative accountability mechanisms? Oops, could whoever is in charge of the Zoom make sure that we can hear Suzanne? Try again now.
Okay, thanks, Natalie. Is that all right now?
Yes.
Terrific. Well, giving a little bit of backdrop for this audience of public international lawyers, we really want to focus on the ancient adage, where there is a right, there is a remedy. And this really reflects the importance that international human rights law gives to the existence of effective remedies, and they really are necessary to ensure the full enjoyment of all other human rights. And as we know, all the major human rights conventions include various measures aimed at ensuring effective remedies for people whose human rights have been violated. And these are often included in the aspects on the right to fair trial, but sometimes they are standalone provisions. And I think this backdrop's important as we start to look at remedies given by way of non-state-based mechanisms, such as we were talking about the World Bank process, or operational level grievance mechanisms provided by companies. We really want to keep in mind that a human rights remedy has two aspects or dimensions. It's not just the procedures and institutions that may be utilized, but it's also the actual actions and measures that are taken to prevent or redress or compensate the violations of a right. And there are 5 categories of reparations, which also we should take into account. As Jeff was mentioning, compensation, that's obviously an important aspect of the right to remedy, compensation both for pecuniary or non-pecuniary harm, but we also have the principles of restitution, rehabilitation, satisfaction, and guarantees of non-repetition. And all of these forms of reparation should, of course, be considered adequate, effective, and prompt. And all of these principles are then set out in the UN Guiding Principles on Business and Human Rights, which is really the foundation of what we'll be talking about today. And the UNGPs envision that there will be 3 types of different mechanisms to address business-related human rights impacts. The first would be the traditional state-based judicial mechanisms. The second would be state-based non-judicial mechanisms. And then the third are the non-state-based grievance mechanisms like we're talking about. And really, these are the ones that are designed to try to help companies address early grievances as they start to manifest themselves, and ideally address them even before they manifest into actual human rights impacts. And we also see in the UNGPs some effectiveness criteria set out for what these non-judicial company-led initiatives should look like. And I think that's an important backdrop to what our conversation will be about, to take into account what these effectiveness criteria are. Briefly, they say that non-judicial mechanisms like this should be legitimate, they should be accessible, they should be predictable, equitable, transparent, rights compatible, a source of continuous learning, and in the case of operational level grievance mechanisms specifically, they should be based on dialogue and engagement. Now, this third pillar of the UNGPs, the right to remedy, has often been considered the neglected pillar. But as you say, the history now is showing an increased level of attention just in recent years to this third forgotten pillar, perhaps evidenced by the fact we're having this session today. But over the last few years, there's been a real push at the UN and elsewhere to focus on it. And for example, in the 2017 report of the UN Working Group on Business and Human Rights to the UN General Assembly, the working group really unpacked this concept of access to effective remedy set out in the UNGPs. And it talked about really we need to look at it from the perspective of rights holders, which is why we had, of course, the video by Jeff, and also focus that on the right to remedy needs to focus on the diverse experiences and expectations of those rights holders. Rights holders should be able to claim what may be termed, and this is what the working group called it, a bouquet of remedies that are suitable to the particular grievance that they have. And they need to be able to access this bouquet of remedies without fear of victimization. And of course, we do know that victims of human rights, as well as defenders of human rights, are often in great danger. So there's a lot of complexity to the backdrop of these mechanisms. And I think that a panel like this is really important to start to unpack the real lived experience of some of our participants in building these mechanisms.
Thank you very much. Thanks very much, Suzanne. As you said, it's now been more than a decade after the adoption of the UN Guiding Principles, and we are several years into a period, an era, where more private and public sector actors are offering these kinds of mechanisms. As we heard from Jeff, some fundamental concerns persist. And as more of these mechanisms are implemented, some next generation challenges may arise. So we're going to dive into these topics in greater detail. Before we do that, however, I'll ask for a rapid response from our panel to kind of get the issues out on the table. What do you each see as the most enduring challenges facing alternative accountability mechanisms as they are now and maybe in the future? I'll start with those who are here with me in the room. Margot.
I'd like to highlight the accessibility challenges that we see, and I think we should look at them in two ways. One, is remedy even accessible through these mechanisms? And two, if so, are these mechanisms sufficiently accessible to the communities who need to use them?
Mark.
I couldn't agree more with Margot on that. I would say the biggest challenges are what can we know about the mechanisms? What do they really do? Because there's an immense lack of transparency. And second, can they be designed to work? Those would be my two questions.
Suzanne?
Well, I also agree with the other two speakers. So might have been my leading challenges, but I'll add then, I find the role of the government to be very challenging, the role of the state. Very often, as we know, often human rights impacts by companies are much implicated by the role of the state. Sometimes companies are considered to be complicit with the state. Other times, it's actually the state being considered to be complicit with the company or facilitating by way of poor regulation, for example, a corporate actor. And so we find in building these non-judicial grievance mechanisms, one of the greatest challenges is what will be the role of the state, which is obviously sometimes implicated in sovereignty concerns and other resistance by the state to be engaged.
As we heard in Jeff's video as well. Archana.
I guess agreeing with everybody else who's gone before me, I'd like to add, the ecosystem within which all of these mechanisms exist has such a strong bearing often on how effective, how accessible, how legitimate, and how credible they end up being. And, from my perspective, I work in the remediation space, primarily focused on supply chain exploitation in Southeast Asia. And one of the acute difficulties there are that these mechanisms are designed to suit the companies and not to suit the affected groups. And therefore, they entirely miss the mark. And that, for me, is a huge issue.
Thank you all. We're going to spend the rest of the time in the panel sort of actually going through these points. I have encouraged our speakers to be interactive. I will be a tiny little bit of a traffic cop, just keeping us on time. So we'll go through each one of these issues. Mark just told me good luck. So we'll go through these issues. Let's begin with accessibility. Margot.
Sure. So I think it's important to take a look at whether or not we're really seeing remedy from these mechanisms. So I'd like to provide us a snapshot across the mechanisms and talk about two case studies, one success and one failure. So with the accountability mechanisms that are attached to development finance, there have been 1,600 complaints globally so far, and about 1,400 of those have closed. And when we look at those closed complaints, only 18% have resulted in outputs. So already, if we're trying to say which ones have remedy and which ones haven't, we've already narrowed ourselves to that 18%. And of that, an output could mean all sorts of things. It could mean a report, it could mean a promise from the bank to do better in the future, or it could mean meaningful remedy for the communities. So we need to unpack kind of where we're actually seeing a remedy and where we're not. And I just want to emphasize that the current state of play, it's dire. We're really not seeing remedy come out of these mechanisms for the most part. And to maybe provide two case examples to give some color to this, at Accountability Council, we're working with tea workers in Assam, India. So the International Finance Corporation invested in a company that runs tea plantations in India where 155,000 workers and their families live and work. And the reason for that investment, or one of them, was for the IFC to bring its strong environmental and social standards to an industry where those standards had been lacking, and to make that experience, the working conditions for those workers better. After the IFC investment, the workers raised a complaint to the IFC's accountability mechanism, alleging that they didn't have running water, their toilets didn't work, they had substandard medical care, they didn't have personal protective equipment when they were spraying pesticides, and they weren't adequately consulted on business decisions that affected them. So the IFC's accountability mechanism undertook a compliance review, which basically is the IFC following its own environmental and social rules? They go to, and they interview people, they do a full investigation, and they issue a public report that says, no, these communities, what they alleged is true. There's substandard medical care, there's not running water, there's not PPE, et cetera. So a public report showing that the IFC did not do what it's obligated to do. So then you would expect, of course, for the IFC and the client to respond and try to remediate the harms and bring the project into compliance. But the accountability mechanism, 3 years after its report finding noncompliance in the first place, went back and did monitoring and found that that compliance still had not been fixed. So what we're left with, and what the communities in Assam are left with, is a win on paper where they can say, we are validated. What we said is happening is actually independently verified to be the case, but it's not meaningful to them, therefore in practice, because they aren't seeing remedy come out of this process. So that is a lingering failure that we see in that case. And just to provide a success or a qualified success as a counterexample, and then I'll hand over this topic to my other panelists. We also work with communities in Haiti. In 2010, there was an earthquake in Haiti, and there was a lot of earthquake response afterwards, right, to help rebuild the economy. So the Inter-American Development Bank invested in building an industrial park. It built that park on fertile farmland, and the farmers there basically overnight and without consultation went from food providers to being food insecure. So they raised a complaint to the accountability mechanism that's attached to the Inter-American Development Bank. And through that, they entered into a negotiation process with the Haitian government and the IDB and the communities, and they negotiated what remedies should be given to them as a result. So replacement land, equipment, jobs at the industrial park, vocational training, school supplies, et cetera. So really tangible remedies. That agreement was reached in 2018, and I can tell you today in 2022, it's only partially implemented. 13 families of the 87 have received land. Some school supplies have been given, some jobs have been given, but not the full agreement yet. 4 years later, it hasn't been implemented. And the fact that even some has been implemented is because the communities themselves have stood up a campaign to say that this win on paper has to be a win in practice. And so it's showing that the system itself alone isn't providing sufficient remedy. It's taking the communities and their advocates to really make it happen. So I'll pause there and see if others want to chime in.
Other thoughts about the challenge of accessibility, either the substantive points, as Margot had raised them, or some more procedural questions about accessibility?
Absolutely, and please stop me if I go on too long. So I work with Nomagea, a nonprofit think tank, and we've been doing research on this area for quite a few years. And we try to get in the point of view of the claimant. The claimant is everything from someone who works in a sweatshop with an individual labor issue, a labor union, a community whose land has been taken. From their point of view, what does it look like? And I would focus on the word alternative, which is they need a place to go to make the complaint, and there is no place to go. They're in a system where the law is not going to work, or it's going to take too long, or it's too expensive. They can't go to the Ministry of Labor. They can't go to anybody. So they're desperate, and sometimes they're physically desperate. And for them, why would you trust one of these systems created by a development bank, by a company, the very company you're complaining against? Hi, we're the defendant and we're the judge. We'll be fair. Come to us. Or a group of companies that you're complaining against. So the lack of trust, often the lack of publicity, they literally don't know, and often language problems intervene. We've had people. The complaint mechanism for a multi-stakeholder initiative, for example, is very proud that the complaints can be made online. Simple. It's really simple. You go into the field, and the complainants say, it's crazy hard. It has to be online, on the internet, in English. We can't do that. So to look at the point of view of the claimants is key, and it's one of the big things lacking right now, I think.
Not seeing a hand up from either of our panelists online. Suzanne, Archana, any other thoughts on this point? Oh, can't hear Suzanne.
Uh,
Yes.
Sorry, I was off mute, I think. I was just going to jump in to say, I mean, of course, I agree with the other panelists. I think then making a grievance mechanism accessible, if you are doing it to assist a company, it is absolutely crucial to take into account all of the things that Mark has mentioned. And there are mechanisms to make them more accessible. We talked about in our preparatory session things like doing even musical theater and performance to try to explain how the mechanism works, making sure people are out in the communities advertising or explaining how the mechanism works. Because you're quite right, an internet site, a website or anything that is not accessible is not going to be effective. And I think that there is a lot of need for creative thinking and really learning the lessons also of human rights systems and how the various regional human rights systems also make their decisions as well as their procedures known to communities, which is often through education and media. But I'll stop there.
I'd like to add that in Southeast Asia, we are really seeing an explosion of worker apps and tools that really, are all about using technology, and all the donors are piling a heap of funding along those areas. And when you actually get out into the field and ask people, how easy do you find it to interact with this? All they'll say to you is, I just want to speak to someone who I can speak to and I can see and explain what my problem is. Mm-hmm. And it's so simple, yet so complicated. And actually, what we really find are that there is a complete blindness and blindsidedness to the suffering of people on the ground, the types of violations that they're experiencing, and the types of remedies that would be suitable. So, for example, we're seeing a lot of multi-stakeholder initiatives that are run by industry bodies. And in many of those cases, when complaints are submitted, the complaints are submitted to be looked at by this body of people who are actually funded by the companies who are the defendant and the judge themselves, as Mark so eloquently put a minute ago. And therefore, that presents a problem in itself. But also when you're looking at these industry bodies, very often companies withdraw from the industry body if a decision is made that goes against them. Or sometimes what will happen is the industry body will take forever to come to a decision. And at that point, people drop off along the wayside because there is a loss of engagement. There is a need to get back and to earn money and not to be stuck in limbo and to really move on, because many of these people are heavily indebted and, are there on borrowed time because, they're on a work permit, which is tied to a particular employer. And engaging in a dispute with that employer is not the smartest thing, or filing a complaint. And, I guess just to close off this point, the debt, the coercive power of debt, the fact that many employers retain the passports of the workers, really fetters their ability to actually even go somewhere and attempt to say that I have a problem, can you please help me?
That really leads, I think, very well into the challenge that you raised, Mark, which is, how do you then design a mechanism that is appropriate for a particular circumstance and context that takes these issues into account?
Yeah, and that's an issue we've been dealing with. To make it a little bit clear of what the lay of the land is, there's the development finance institutions that Margot is very much an expert on. I would say the other two big areas are what we keep calling multi-stakeholder initiatives. So these groups like the Roundtable for Sustainable Palm Oil, the Fair Labor Association, the Aluminum Stewardship Initiative. There are many, many of those, and many have or claim to have complaint mechanisms. That's one category, and it's important. And another category is the companies themselves. Complaints either directly to them by their own workers or by communities outside, or in their supply chain. Many apparel brands, for example, have a complaint mechanism that supposedly includes complaints to their supplier factories. Okay, so those are the two big groups. For the multi-stakeholder initiatives, what we have found is, exactly what like was said, if the respondent or the defendant in the claim is a member of the group, our research has found almost no effective remedy ever being provided by those systems. Pretty remarkable. If, however, the respondent is not in the group, classically a supplier to a member of the group, so there's actual financial leverage over this outside supplier, there can be situations, when it's done right, in which remedy can be provided. That's one finding. So the basic, until we see otherwise, the idea that a multi-stakeholder initiative can have a complaint mechanism for its members that works, we have not seen that yet, period. For the company mechanism, there is a very painful lack of transparency to know. It's almost impossible to do research on that, and very few, except for a few notorious cases that have been studied repeatedly, both by the same company, actually. There's very little information on that. So this lack of knowledge of what works for the company side, it might be working, it might not. We don't know. You combine that with the new laws that are coming out, particularly in Europe, Germany, Norway, and the EU directive, which require companies to have these complaint mechanisms. So we're in a position where we don't know if they work, but they have to do it anyway. So it's a very challenging time for this. The short answer is I think there are ways to do it, but it takes a lot of effort, it takes commitment, and including a financial commitment. And it takes an independence outside of the respondent.
No, thank you, Mark, and thank you to audience members who have already begun to submit questions. For the benefit of the panel, I will read them out, and feel free to incorporate them into either your contributions on this point or as we turn to the other challenges that had been identified. First question. It strikes me that industry bodies and company-based AAMs, alternative accountability mechanisms, often don't really have an incentive to engage meaningfully with communities. How can AAMs truly work to align their incentives with those of communities rather than those of companies? Next question. If formal legal remedies and alternative accountability mechanisms are failing from the point of view of the claimant, does the desperation you mentioned lead them to seek non-legal or non-official sources of relief? Next one. Sometimes national legal protections are much stronger, but beneficiary companies argue that they're meeting World Bank standards of community engagement. How can this dichotomy be addressed? And then finally, for now, these are excellent questions, thank you all. When mechanisms fail, are farmers turning to alternative private remedies such as the UN's Contract Farming Initiative, where farmers can negotiate directly with private buyers? So again, as I said, you can pick these up in any thoughts that you have on the points that Mark made, especially about meaningful structure, the alternative in the different categories of mechanisms, or in the points that Suzanne made about the role of the government, or coming back to the ecosystem and sort of getting to an effective remedy, as Archana said. Looking at the clock as well. So this will be any thoughts in response to those questions in light of the meaningful structure point.
Yeah, if I can just add to tie together what Mark left with, which is that it is possible to have mechanisms that work, and kind of trying to answer that first question about how do we make that so and how do we align incentives. Part of it is providing the accountability mechanisms with an adequate mandate in the first place. So currently, most of the accountability mechanisms don't have a mandate to even recommend remedial actions, let alone obligate the company or the investor to provide remedy. So if that mandate is given to them and that it's clear and transparent that it's there, that would be a game changer, right? So currently what we have is those misaligned incentives, like the person asking the question said, which is that these mechanisms aren't always independent and they're still beholden to the company or the investor that they're attached to.
Any other thoughts from Suzanne or Archana on this point?
I mean, I'd just like to say that one of the interesting developments we're seeing in Asia is everybody's been following very carefully the developments in Europe around the mandatory human rights due diligence law, because it'll obviously have an impact, direct and indirect, on Asian businesses. And of course, there is a big focus on remediation and human rights due diligence, which come both, hand in hand. And one of the things that, one of the discussions we're having is how do you invest buyers in the process of helping to improve the levels of engagement and the investment in the extended supply chain. So where smaller and medium-sized suppliers do not have, any kind of infrastructure around remediation for their workers, how can buyers be investing in remedial mechanisms in order to make these systems a lot more accessible to these workers? There was also a question asked around, are people going outside through non-legal means, etc. We've observed two things in particular. At the moment, there is much more leverage in going directly to a buyer if you're an employee of a small supplier, rather than to go through a mechanism which is run by a multi-stakeholder initiative. So somebody would go, a supplier would go straight to Tesco's in order to see what relief can be obtained very directly from Tesco for issues that have happened at a smaller supplier level. There are more chances of recovery that way and of remedy that way than anything else. There have also been several instances of settlements that are brokered by NGOs in the field in a very non-transparent way on behalf of workers. And often because the workers are so desperate, are really debt-ridden, don't have their passports, are unable to go left or right or do anything, they will often agree to a very, very modest settlement that barely represents what is owing to them. Right. And underlying all of this is the fact that there is no systemic change that accompanies any of these forms of remedies.
I guess I could jump in. I mean, there's so much to be said, but on the point about the mismatch of expectations really between companies and communities who are accessing grievance mechanisms, I think it is really important to think through the different perspectives and try to find an accommodating middle ground, which I think is why the UN Guiding Principles talk about, in the first instance, these mechanisms should be based on dialogue and engagement in order to try to really facilitate some form of learning on both sides. And of course, often it's the company really that needs to experience the learning. And there's a real impediment that we've found, and actually, in a way, I wonder if the new EU directive on mandatory due diligence will assist this reluctance by companies to engage with remedy for fear of litigation and for fear of liability risk, which has the perverse effect that they very often avoid engagement and addressing harms that they have identified, even that they have been implicated in or caused. And I think hopefully the requirement that you do due diligence, you're required to identify these risks, will then lead to potentially an expectation that you will address them in order to avoid litigation. I mean, that's the proper way to look at it, rather than that will lead to litigation. And then the other real tension is trying to explain to companies what remediation or reparation does constitute under international human rights law. And yes, it's compensation for pecuniary and non-pecuniary harm. Excuse me. But it's also all of the other things that I listed, and potentially, non-repetition is a very important aspect of it, as well as satisfaction. But non-repetition, to try to really identify what was the underlying root cause of a particular grievance and try not to repeat it. And I think if you can persuade companies that there is a learning aspect to all of this, and an ensuring that you do head off grievances before they manifest themselves into litigation in home courts, you can start to make some progress with getting companies to engage and understand that it's this whole bouquet of potential remedies that are not necessarily the kinds of remedies that they might find so very threatening as you would find in a court system. So I think though it's still a learning process for both sides.
Thanks very much, Suzanne, and everyone. Since you have the floor, Suzanne, we'll turn back to you. You, in both your comments just now and what a lot of the other panelists had said in response to questions, you focused on companies and communities. I'm going to pick back up on what you had identified as one of the enduring challenges, which is the role of the government and the relationship of the government to these kinds of efforts. Could you speak a little bit more about that, please?
Sure, of course. I think, Mark touched upon the fact that some of the more notorious situations of human rights impacts involving companies are the ones that have made headlines in terms of their grievance mechanisms. But we can learn from some of those. The tensions that I see are often where it's actually the state whose actors are causing the harm, if we're talking about really serious human rights impacts. So often it could be the police who are protecting, for example, a mine site, or it could be the labor inspectors who are failing to identify child labor and failing to provide access to education for the children who are found in the fields. Or the state may be implicated because its judicial system is allowing strategic litigation against the actual victims of the corporate abuse, as well as threatening human rights defenders. Or the state may be implicated because it's ineffectively regulating the company and essentially facilitating some form of human rights abuse. So we really have a whole panoply of areas where the state can be implicated, and to try to build a mechanism that can address that and have this influence of non-repetition that I talked about, so that we can actually move forward, not only providing a remedy for the immediate impact, but try to shape the future, is quite complex. I've found that the involving the state is much easier when there's a strong national human rights institution. So, for example, Latin America, often the ombudsman's office is quite strong relative to, for example, in Asia or in Africa, where you don't always see such strong national human rights institutions. And that ombudsman office in Latin America can often play a very good facilitating role to make sure that the state is engaged with the grievance process by a company trying to really address underlying root causes of whatever the tension is with the community. But you can envision it's very complicated when you try to involve the state, but these things are complicated. So I don't know if others have experience with this.
I mean, I'd like to throw my hat in. I do a lot of advisory work for governments in the region and have likewise represented a lot of workers in their cases as well. I think, where you have geographies and jurisdictions that allow prolific use of criminal defamation laws against workers who are seeking access to justice, but also against human rights defenders, and where you have trade union laws that prevent migrant workers from engaging with any kind of trade union activity. And, where you have a labor inspectorate of 70 inspectors for a huge geography, which has very remote locations, sectors like palm oil, rubber, etc., you're setting yourself up to fail. And the other thing that we noticed as well is that there is very little engagement and dialogue between the private sector and the state, which also reflects, sometimes in the response that the state demonstrates when faced with issues. So just to give you an example, there's been prolific activity by the US Customs and Border Protection in Malaysia against rubber, against palm oil, etc. And, in response, there are new laws around forced labor that have been tabled. There's a national plan of action on forced labor. Still very poor dialogue between the government and the private sector. And, on a day-to-day basis, what we are not seeing is any change for the affected communities, who are experiencing violations on a day-to-day basis. The most significant impact of the sanctions has been to push the companies into refunding recruitment fees. But that never pushed them into thinking that actually all of this is preventable. It would be better to have systems of due diligence in place to ensure that we don't find ourselves in that situation in the first place and are able to manage it. So we're still seeing very knee-jerk reactions to things like sanctions, as opposed to a more holistic approach of human rights due diligence is the right way to look at it. And across the jurisdiction, Thailand is the only country that currently has human rights due diligence laws and the requirement for remediation mechanisms at public listed company level. And Japan is set soon to announce some guidelines around disclosure, remediation, and due diligence as well. But this is primarily in reaction to the upcoming European law.
Margot, Mark, other thoughts about the role of government?
Yeah, maybe just quickly to echo everything that Archana said, and maybe to just add one piece to it. At Accountability Council, of the 50 cases that we've had to accountability mechanisms, for the most part, we've seen, unfortunately, the role of the government committing reprisals, trying to not support the human rights defenders who are trying to raise their rights. But there have been a few cases where governments have actively engaged in the process to help reach an equitable outcome. So I want to say it's possible, right? And I think the message that Archana said as well is that more sustainable investments can occur if these type of processes are supported. So it's good for business, it's good for governments, and most importantly, it's good for communities if they're recognized as these tools that can actually help everybody and be constructive. But we're still seeing that knee-jerk reaction, and I think some of it has to probably do with the fact that often the people trying to access these mechanisms are already the most marginalized in their communities, and therefore we've got the power dynamics in the world system that we understand. But we know that these mechanisms can be transformative if everyone chooses to engage with them.
Yeah, wonderful, wonderful comments. A lot of knowledge goes into those comments. Thank you for those. I don't want to sound like Ronald Reagan, but where we go, the government's the problem. It's not the solution, almost ever. And it's everything from literally killing, for its public security forces, the claimants, to just having lawsuits, legal claims that go on forever, so that no one ever gets remedy. So the fact, if there was human rights enforcement at the government level, we wouldn't be talking about this. So the government intersection is almost always negative. Looking at the claimants' point of view, and we've sat down with many, many claimants and say, why did you pick this system at that time? And they go through the list of their options, and there's usually a list, including court cases and ministry cases, NGO complaints, protests, everything you can imagine. And the choices are almost always all bad. It's a choice of systems that don't work. And they're trying to find the one that doesn't work the least. And that kind of desperation, particularly if your community's land is taken or your community is destroyed, that frustration we have seen when these systems don't work leads to violence. So this is not, these are not trivial cases, right? These are things that need to be handled and they're not being handled, and it needs to be improved. So the intersection with law at the extreme point is the frustration with the systems lead to criminal acts, violent crime, violent protests, destruction of property.
So we come in, unfortunately, the last few minutes of the panel to, in many ways, sort of the objective, the goal, and the heart of the process. And Archana, the way that you had described it when we were doing the rapid round robin was, sort of the entire ecosystem in which these processes and these mechanisms are placed, and in many ways, kind of the critical question of, well, what is a remedy, and what will be viewed as a remedy by the individual, the community, the claimant? Can you kick us off this last round of comments with the core question of effective remedy?
I've thought about this so much, and it is heartbreaking when you're working with people who felt for the longest of time that it was okay what was happening to them because it was happening to everybody else who was around them. The exploitation that we see is so normalized that at some point, throwing the smallest bit of a solution of some description becomes a remedy. I've grown, completely. We've started to accept the fact that providing a little bit of your recruitment fee back to a worker is actually effective remedy. The whole notion of what it is has become so distorted. And it is so important, as Suzanne set out at the outset, to go back to that bouquet of remedies. And sometimes a situation may call for an apology, it may call for a guarantee of non-repetition, it may call for damages for pecuniary and non-pecuniary loss. Another situation may be different. And I guess we really need to be in systems that allow people to vocalize what it is that they want, but that also allow them to see what they lost. Because many a times the workers that I work with actually don't have a sense of what they've lost, because it was never clear to them what they actually had to start with. So I think, for me, remedy really means people being understanding and being helped with appreciating what they could have, what could be done to make the situation better, and how do we make the leap from offering a person a solution to changing a system so that it doesn't happen to the next person.
Suzanne? Back on mute?
Not.
Okay, yes, now we can hear you.
Thank you for change. It wasn't me. I wanted to pick up on some of what Mark said. I mean, I completely agree that it's usually the state's absence that is part of the problem, and the state is not playing a helpful role in many of these situations. And in fact, explaining that to companies in that they need to, when investing and operating in jurisdictions where the state may not be strong and may not be effectively there to provide remedy, that is why we're having this conversation, and they need to step up. And they need to step up to avoid all of the consequences, not only, of course, because it's the right thing to do and because you should not be implicated in human rights abuse, but also because now we have an expectation globally that what happens in host country will come home to you in your home country through these due diligence laws, et cetera, and it behooves you to address these concerns. But also it will avoid potentially costly protests and violence and boycotts, et cetera. And to look at it from a perspective of why a company should engage, it's important to explain all of that to them. Now, flipping it the other way around, it's also very important, as others have said, to look at remedy from the perspective of the rights holder and ensure that they are able to craft the appropriate remedy suitable to their expectations. And I think that that's often, it's extremely important, especially to ensure that these mechanisms aren't more harmful than beneficial, because the last thing you want is for the company and the community to enter into some sort of agreement that is actually detrimental to the rights of the rights holders. For example, waivers of liability or issues that, in fact, ensure that these grievances are not addressed fully and actually effectively, so that whatever the harm is not repeated. So there's a lot of cautionary warnings, I would say, that need to come with these mechanisms, because you are taking this out of the context of the state, and you have private actors shaping both the remedy system as well as potentially the actual remedy or reparations that are being provided. And it's extremely important that there are some precautions taken to ensure that the rights holders are protected.
Thank you. Mark and Margot, quick final thoughts.
Remedy is one of those bottomless issues that the legal systems of the world have dealt with for thousands of years. If your negligence kills my daughter, what's my remedy? Legal systems try to address that. The fact that remedy is a bottomless conceptual problem doesn't mean it can't be addressed practically. I think the fundamental comment, and something that can be built in systems, is that at the very least, at a minimum, we need feedback from the claimant that the remedy was substantial and meaningful to her. And without that feedback, you really never know.
Margot.
I wonder if I could leave us maybe with 2 calls to action. So one for the investors or the companies that have these mechanisms: set up a remedy fund. Have something there for when you have an outcome of this process so you can actually address it. and then maybe a call to action for us as lawyers in this space to really look at what is our role in the solution, but also what is our role in the problem. And I think as lawyers, sometimes we can be conservative, litigation-minded, risk-adverse advisors to companies, and therefore say the more you find out, the more environmental and social problems you hear about, the more risk you're creating. But as Suzanne put so eloquently, really we should have this more expansive and holistic look that says if you learn about something, then you can fix it. If you hear from the rights holders, then you can address it, and you can have sustainable investments and good corporate health instead. So.
Thank you to all of the panelists. If you can join me in thanking those both in the room and on the screen. For those for whom this was an introduction to alternative accountability mechanisms, this has just primed the pump. For those for whom you work in this field, hopefully this will reassure you that attention continues to be paid. And for everyone, I hope that this is just the start of the conversation that will continue throughout the meeting and elsewhere. Thank you all.